Great, thank you everyone. My name is Courtney Oliva, and I'm the Executive Director of the Center on the Administration of Criminal Law here at NYU Law School. And the center is thrilled to be able to partner with and host the New York City Criminal Justice Agency as they present their report, Understanding the Past, Imagining the Future, 13 highlights from 30 years of New York City criminal justice data. I just want to make sure that everyone was able to get a copy of the report as well, because it was available out front. If not, I think someone can come through, and if you raise your hand, and we can pass out the report. And I say that just because at some point, highlights from the reports are going to be displayed up here on these screens to make it easier for you, for those in the back, if you are not able to see it. And obviously, you know, understanding the data that goes into our criminal justice system is fundamental and the first step in being able to evaluate what we're doing right and what we're doing wrong. And so we're extremely excited to hear from these panelists today. And with that said, I'd like to introduce Aubrey Fox, who is the Executive Director of CJA. Thank you.
Good morning, everyone. And thanks to Courtney and the Center on the Administration of Criminal Law here at NYU Law. This is the second event we've hosted at this beautiful space. It's really a remarkable room, maybe one of my favorite rooms in the city. And so I want to just set the stage a little bit to talk about why we wanted to have this event before I introduce our distinguished panelists. Before I start, though, Michael Jacobson, who's the chair of my board, came up to me, and the first words he said to me were, "Is there going to be any conflict this morning, or is this a love fest?" which, in addition to being slightly disconcerting to hear from your board chair, suggests maybe what Michael's desire for public events is. And so the bad news for Michael here is that working together, CJA and the Mayor's Office of Criminal Justice have solved all of the problems in New York City. So we're just going to have a little victory lap for the next hour and a half. Okay, so there's really two reasons that we wanted to host this event. As many of you know, CJA is the city's main pretrial services agency. We work under contract with the Mayor's Office of Criminal Justice. And every year we release something called the annual report. I'm holding a copy of the most recent annual report in my hands. This is the 2016 annual report. And in contrast to what I think are a typical organizational annual report, which is more or less a brochure that testifies to how awesome the institution is, in this annual report, what we provide is a kind of compendium of key criminal justice statistics for the city, using this quite remarkable criminal justice database that we have managed and nurtured with the partnership of the Mayor's Office for now over 3 decades. And so we wanted to talk a little bit about the annual report and why it exists and what it hopes to accomplish and what it says about New York City that we have such robust data to draw upon in making criminal justice policy. We also want to talk a little bit about a kind of supplemental paper that all of you should have in your hands, which Courtney mentioned the title of, Understanding the Past, Imagining the Future, where we did something that we haven't done with our annual reports in the past. We've been doing this, again, since 1987, releasing an annual report or a semi-annual report every year. We decided to take a kind of deep dive into 30 years of reports and try to find some interesting highlights and trends from the last 30 years. And so we're presenting that paper today, and we'll be displaying some of the pages of this report, but you can follow along in your paper, and we'll make sure to refer to the particular highlight we're talking about. Okay. So I mentioned a minute ago that we're joined today by 4 distinguished panelists who are going to help us grapple with what I see as 4 kind of headline stories from this paper. We have 13 highlights and 4 big stories. And after we go through each of these stories briefly, we'll conclude with some audience Q&A. And we have a kind of slightly different approach to Q&A than maybe is the norm. So what we're doing is circulating note cards. Some of you may have already collected note cards, but we have staff who will be walking around and distributing them. You are free to write down questions in the note card at any point during the session. They'll be passed up to me, and I'll choose some of them for the Q&A session, and I may even break into the kind of operations before then to ask particularly interesting questions. And apologies in advance if I don't get to all of the questions. Okay, so let's talk a little bit about our wonderful panelists this morning. So to my left is Elizabeth Glazer, who's the director of the Mayor's Office of Criminal Justice. She is the Senior Criminal Justice Policy Advisor to the Mayor and First Deputy Mayor. Important job. And she previously served as the Secretary for Public Safety to Governor Cuomo and at the U.S. Attorney's Office for the Southern District of New York. So Liz is someone who has built her whole career and has a lot of experience on using data to inform criminal justice policy. To my immediate right is Michelle Sviridoff, who is the Deputy Criminal Justice Coordinator Emeritus for Research and Planning at the Mayor's Office of Criminal Justice. That is a mouthful of a title. She has served in research and planning capacity at the Mayor's Office of Criminal Justice for over 15 years, working both with Mayor Bloomberg and Mayor de Blasio. And Michelle and I worked together many years ago at the Center for Court Innovation, where she was a deputy director. She's also a member of our board. And unlike Michael, she did not ask me any challenging questions before we started today's meeting. After Michelle, we have Jim Jacobs, who is on the law faculty here at NYU Law School. Jim has written a series of important works and books, including most recently a really fascinating book called The Eternal Criminal Record, which looks at how criminal records cast a shadow on over 60 million Americans. He's also the author of Does Gun Control Work?, which is a topic he is returning to in a forthcoming book about some changes in New York state law. And Jim was also a member of CJA's board for many years, so he knows our annual reports and our research well. And then down at the end, we have Dr. Frida Solomon, who is a senior research fellow at the Criminal Justice Agency. She joined CJA in 1988 and has written widely about New York City criminal justice, including studies related to drug enforcement initiatives and studies looking at defendants charged with quality of life offenses. Okay, so before we dive into the highlights, I just wanted to spend 1 minute talking about why data matters in criminal justice and how data is a fundamental part of CJ's as an institution, dating all the way back even before we incorporated in 1977 to the very foundations of the institution in the Manhattan Bail Project. The Manhattan Bail Project is one of the most important experiments, research-informed experiments in criminal justice. Launched in 1961 and essentially proved that you could release a defendant without bail on their own recognizance, and the outcomes in terms of new court appearance and criminal offending during the pretrial period were just as good, if not better, for defendants released on bail. And that experiment, which was done through a kind of quasi-randomized controlled trial in New York City in 1961, essentially created this institution of release on recognizance, which now, 50-plus years later, is one of the more remarkable and enduring features of the New York City criminal justice system, where we have a system that essentially is remarkably humane for the majority of defendants who are awaiting trial. And in contrast to other jurisdictions around the country, makes much more use of this particular sentence. And so we use data as an agency in a couple of ways. We use it for our operations. We can't operate our programs without the data that we generate ourselves through our pretrial interviews and receive from the state for the purposes of creating our pretrial release recommendation. But we also use and maintain data for research purposes. And I think that's kind of an important thing to note, that in the Manhattan Bail Project and in the charter and contract that we signed as an agency in 1977 with the Mayor's Office of Criminal Justice, which I would dare say is the most important document since the Magna Carta, really enshrines this idea that we serve a dual purpose, that we are an operations agency, and we couldn't be more nitty-gritty as an agency. We have staff working in courthouses around the city 24/7, interviewing defendants, making release recommendations to the judge, helping defendants who have bail navigate the bail payment process, running a supervised release program. The list goes on of our operational responsibilities. But we also have, as kind of a core component of our agency, this idea that we use data to inform policymaking, and that we use data to inform the public and stakeholders, and have this data set that I do believe would be the envy of any other jurisdiction in the country. And for me, what's really remarkable about that is, fast forward to today, and I think two things are true. People are focused in a way that they haven't been in decades on pretrial justice and the role that pretrial decision-making plays in problems like over-incarceration and the high number of people who are held in custody. And certainly we know that in New York City, addressing pretrial justice issues is a key, if not the key, towards this goal that the mayor has articulated of closing Rikers Island. And so it's nice to feel like the agency's purpose, which was set all those decades ago, is all the more important today. And I think the other thing that people are recognizing is that a kind of fundamental obstacle to reform of the pretrial justice system is, nationally at least, a lack of data. And some of the outcomes that we are going to present to you today do not exist in any workable form on a national basis. So what we are about to tell you about release on recognizance rates, about bail making, and other issues, you simply cannot stack up against other cities because there's only a handful of cities that actually know this information themselves. It's not reported nationally, it's not collected. And that, I think, for people who start to confront these issues of pretrial justice and pretrial justice reform is just an enormous obstacle to making change. And in your paper that everyone has, on page 1, we have a quote that I think stands out as kind of almost a mission statement for the agency, written by Amy Bach, who's a really exciting criminal justice researcher and thinker who's trying to solve this national data problem. I just want to read this quote, and then I'll stop talking after that and turn it over to the panel. But what she wrote in the New York Times was, criminal justice data in this country is hard to come by. It can be messy and difficult to understand. And in many cases, the data doesn't exist at all. Missing data is at the core of a national crisis. No credible business would ever make a large investment in criminal justice without being able to gauge its success. Information should be available to everyone. It can't be limited to a small group of local professionals who themselves have only access to an incomplete database or old documents in the basement of a county building. And I think really the purpose of the annual report and the work we're doing today is to answer that challenge that Amy Bach has set for jurisdictions around the country. So I think where I want to start is with Liz. And what I want to say is, you know, it's common, I think, now for people to talk about New York City as the safest big city and the city with the least proportion of its residents who are incarcerated. But I don't think this story about how the city has a more robust set of data than anywhere else in the country is told as much. And so at the risk of sounding completely self-congratulatory, I want to ask Liz if she agrees with that contention, and just generally to talk about, you know, how you use data to inform policymaking, and if I'm overselling this, you know, a little bit of a reality check too.
So we probably should have spoken before. And just give me a hand signal if I'm going the wrong way.
This is the conflict that we're planning to introduce. Liz has no idea what our plan is.
All right, exactly. So I do think, you know, the work that CJA has put out and the way in which they have used data to try and educate the public, which is so crucial about what's actually happening in our justice system, is fantastic and probably unparalleled. I never leave New York City, so maybe in other places. And I think that's really crucial. But I think that data, the access to data, and the heterogeneity of data is still a really big issue in thinking about justice issues and in trying to address justice issues and in trying to be as targeted as possible in actually finding solutions. And so I'll give you just a little bit of an idea of what I mean about that. So CJA has linked together a bunch of different data sets that are very, very important. And you'll see it in these terrific reports that Aubrey discussed. But we live in a world of a bigger context, and it's not just justice players, both inside and outside the mayoralty, but it's broader issues beyond that. And I don't want to sort of float away on lofty ideas, so I'm going to make this very concrete. So first, we absolutely need to understand agency by agency what's going on. And in many agencies, you know, the data systems consist in logbooks and on hamster wheels, you know, and rubber bands, and it is extremely difficult to link them together. The second thing is that not everybody is, one, there are just issues in sort of creating the data. Two, there are real issues in sharing data, both agency to agency and with the public. So you think about sort of the police department, DA's offices, crucial parts of the system where we really don't know what's going on, and so when we sort of come to ask the questions of why, it is very, very hard to understand exactly what's driving what. And so, yeah, we are at a place that is good and a hard-fought place, I think. We have a pretty steep hill in front of us, and we need to sort of figure that out within the justice system, and then we need to figure out all these other vectors that affect the justice system, the health systems, shelter systems, where we also are not great at linking those things together. So can I say just one last thing? Because I realize I'm sucking the oxygen out of the room. But so, you know, I think about something like our jail population. So New York City, unknown fact, has the lowest incarceration rate of any big city in the US. It's about a quarter of what Philadelphia is. It's almost half what LA and Chicago is. And that's through very, very intentional efforts. But one of the issues that we're seeing as we shrink the population is that there are really sort of two issues that remain. One is the issue of violent offenders and how do you shrink that population. But the second, to this point of sort of multiple interlocking data systems, are people who, you know, have kind of this trifecta of issues that they're dealing with that mean that they hit the justice system, shelter systems, and health systems over and over and over again. And so in New York City, there's been some terrific work done by our health professionals showing that there's this very small group that is essentially in our jails every 6 weeks for 10 days. And what do we do about that? So that requires us kind of blowing the doors out on, it's not just about what we traditionally think about as law enforcement or justice issues, but other disciplines and concerns that are at the fore. And I got more to say.
Yeah. Oh, okay. But you'll hold it for the moment. All right.
Yeah.
Yeah. So Michelle, I think of you as kind of like an ideal consumer of our CJ annual reports. If you're not interested in them, then we're really in trouble. So tell me about how you use them and how you've come to kind of interact with them.
So I've been watching CJA reports for almost as long as you've been putting them out. First at the Vera Institute, then at the Center for Court Innovation, then at the Mayor's Office of Criminal Justice. And, but particularly over the past 10 years, they got richer and richer and richer. And so when I get a CJA report, I sort of leaf through to see, well, does anything leap out as changed? So I'm going to do my anecdote, because when I looked at the 2016 report, and I may have noticed this last year and forgot, but there's, early on in the report, there's a little section that looks at the breakdown of the percent of defendants who are employed or in school full-time, and they break it down by race. And this year I noticed, in my memory, The highest rate was for white defendants, second would have been Hispanic, and third would have been black defendants. And this year I noticed, no, Hispanics had the highest rate. Hispanic defendants were more likely to be employed or in school full-time than white defendants, than black defendants. And I went, wait, is my memory wrong? So I went online and went back 5 years, and my memory was correct. Something changed. In the heart of the recession, when I first looked, because 5 years ago would have been 2013, white defendants had the highest rate of employment. They didn't budge between 2013 and 2016, whatever that first year was. But we saw an increase in employment rates among both Hispanic defendants and black defendants, meaning that the recovery has benefited a group that's very hard to employ. Now, I'm inferring a lot without a lot of data, but just there's little nuggets in there. And so I always look for both the little nuggets and the big trends. I also, I'm not sure what the year was, but there's a section on CJA programs. I'm sitting in the mayor's office and listening to the Office of Management and Budget complain about the first 3 days of jail, which cost the city more than any other days. The fact that many people are admitted and walk out the door really quickly, make bail really quickly. And the question is, can you front load that? If you know they're going to make bail, can you make a difference? CJA was operating the bail expediting program in 2 boroughs. I called up and said, can we do a deeper dive on that? And we ended up expanding it to all 4 boroughs, and just this year it's been expanded again. And small initiatives like this are part of the reason why we see a dramatically shrinking jail population. So I've used it for policy, I've used it for ideas about how the city's changed, and often, as Frida knows well, if I catch a mistake, I call up and complain.
I'm on speed dial.
An ideal reader. So Jim, you work in criminal justice policy, not pretrial justice policy per se, but you've done work on gun policy and other areas. And do you want to say a few words about kind of how data has informed your research?
Sure. First, I want to say the Manhattan Bail Project in the early 1960s was a collaboration of the Vera Institute with NYU Law School. So, it was the NYU students who were the first ones who were out there and doing the interviewing, and they were the forerunners of CJA. So, looking back historically, I mean, it's fitting, that we're here assembled at NYU and looking back and paying some tribute to those early pioneers in pretrial justice. The first thing that strikes me about this event is the transparency, the commitment to transparency, and maybe as an academic, that really stands out to me, because it is not typical or even usual to find government agencies committed to transparency. As somebody who's been a lifer in academia, just the constant struggles to find out basic data about how our government agencies are working, and to get information which is legally public out of agencies remains very, very difficult. And so this CJA really stands out, is not only do they provide the data, but they affirmatively and aggressively present the data and encourage people to read it. And that's just really a standout. Another thing that stands out is, of course, as everybody will say, is New York City as an outlier, and the way our pretrial justice operations work here is really amazing and should be a bellwether for the entire country as to what is possible. If we can do these things here, then that rejection of kind of the hopelessness or the position that it's impossible in other places. So we're really setting a model here for the rest of the country and probably for other countries as well. As I read through this, I was wondering about usefulness for decision makers. You can have great data, and that is necessary for good policy making, but is it sufficient? It's not so easy to just look at data, as all of you know, and then to figure out where this should lead in policy and what are its implications. That is a whole nother process, and it involves a whole cast of decision makers, particularly, I think, here the judges, but also the DAs. And you know, the mayor's office is important here, but maybe even more important, how the judges, at least that's how it appears to me, use these data and reflect on it. And we should have programs here and elsewhere talking with judges about what they're seeing in this data and what lessons there are. It's useful for academics, certainly, very useful, and I think this work is crucial for our understanding these days and our interest in pretrial justice, and pondering what we're doing in pretrial justice. One of the things that stands out is the large number of cases that are never adjudicated formally. So you have so many cases coming into the system that are resolved by adjournments and contemplation of dismissal, but and there's never a formal verdict. And so our model of people arrested and adjudicated doesn't apply to a large part of the population that goes through the system. And then finally, one would want to know how this data impacts on the media and public opinion and a public understanding about criminal justice. And here, it seems to me there's still a lot of massive misunderstanding, and you hear all the time that the jails are overcrowded and that we are in a crime epidemic and we're in a violence epidemic. And even among people who would otherwise be pretty well informed, their understanding of what's going on in New York is really inaccurate. And so I know from this audience we're dealing with people who primarily know the system very well, but it's not disseminated, I think, well to the larger public. So that's something to think about, too.
Thanks, Jim. So I've gotten my first questions from the audience. Please feel free to fill these out and pass them up to us. Joanne from our staff is going to come and distribute cards if you don't have them, or take cards if you have questions. Okay, so Frida, why don't I just have you briefly kind of help make sure that everyone understands the CJA Dataset 101. What is the data that we have that we keep talking about?
CJA has always needed information to support our pretrial services activities. And while I think most people know that CJA is the organization that has court staff interviewing people held for arraignment, providing that interview form to the courthouse stakeholders at the criminal court arraignment, along with a recommendation classification. But I think that many people don't see the much broader array of pretrial services that CJA provides. And from early on, that has included court date notification. So CJA needs to know what has happened. Is the case ongoing? What is the release status of the individual? And if released, we will notify the defendant, if we can contact defendants, to tell them about their next scheduled court appearance date. We also, therefore, need to be able to track from one court appearance to another. And when CJA began to develop the pieces of its information system, the state of technology kind of reminds me of some of those dinosaurs prehistorically roaming the earth. They were lumbering, they were slow, and they became extinct. So the amount of information that CJA could collect was actually quite limited. And I think we all live in a very different technological world when we look back over the 40 years of CJA's existence. And also as CJA's pretrial services activities, as Michelle mentioned, our BEX program, as we have expanded our pretrial services activities, we have needed additional data to support those activities. And so CJA, first and foremost, maintains an information system that is structured around supporting the operational activities of the agency. It is not, by any stretch of the imagination, what most people think of as a research database where you ask questions and you know how you want to structure your survey instrument. So we work collaboratively with our wonderful IT staff when we are trying to extract information to provide information and research services to the city. And providing information and research services, as Aubrey said, has been part of the agency's contractual arrangement with the city from its very beginnings.
Great. So let's dive into the paper. I'm going to turn this over to Michelle in just a moment, but I want to kind of walk us through the structure of how this will work. So I will present the first highlight. We're not going to go through each one exhaustively, but you'll find on page 5 of your report if you're unable to see it from your chairs where it is projected on the screen. And this one I think is an interesting highlight for us because it shows us that the 30 years that we have collected this data set really allow us to see more or less the entire roller coaster ride that New York City has been on, from a high arrest volume and high incarceration rate jurisdiction to the place we are today, where volume has certainly come down dramatically. And this idea of an incredibly shrinking system is part of what will kind of inform and cross-cut as a theme in all of the highlights that we present. But just so that you understand what we're showing here, we looked at the number of prosecuted summary arrests in 1987 and show you some data points from when it reached a high and then came down again. And so this refers to the number of interviews, pretrial interviews that we do as an agency in the courthouses in the 5 boroughs. So with that, I want to turn to Michelle, who is going to talk about one of the stories that we're really interested in, which is the release on recognizance story.
So highlight 2 shows us the 30-year trend in overall release on, well, I'm going to call it ROR rates. So in 1987, the ROR rate overall in New York City was 53%, meaning half the defendants were released without money bail. By 2016, that number had increased to 67%. So a fairly substantial and relatively steady increase. You see a small dip in the early 90s, and then gradually things started to grow and started to grow. And I think we'll get a little more granular and look at the past 10 years a little bit later, but the 30-year trend showed an increase. One of the factors that affected that increase, though, was back in 1987, 53% of the cases were non-felonies. By 1994, that had shot up greatly. In the early years of Giuliani, there was a sharp focus on the non-felony arrest, the misdemeanor arrest that dipped a bit around 2001, 2002, came back, and then has been falling again in the most recent years. But by 2016, we were still up, and 77% of summary arrests, these don't include the DATs, 77% were non-felonies. Highlight 3 gives us a little more detail on this, because you can look at the trends separately for felonies and non-felonies. So between 1987 and 2016, the overall ROR rate for felonies was basically the same, 42% and 43%. There was a dip in the ROR rate, you can see around 2001, 2002, and those were years in which arrests plummeted after 9/11. 2002 had a relatively low arrest rate. So the felony arrests may have been those that were most serious and had a lower ROR rate, but the overall trend didn't change over that 30-year period. But where we see the big difference is for the non-felonies. So in 1987, 68% of the non-felony population got an ROR at arraignment. By 2016, we were up to 79%. And that's the big growth area in ROR. Highlight 4 breaks it down a bit more over the 10-year period where we saw the greatest change. So between 2007 and 2016, overall ROR rates increased from 59% to 67%. We saw differences in both felony cases, up from 38% to 43% in ROR, and in non-felony cases, up from 71% in 2007 to 79% in 2016. If I may, I'd like to point out a few things that happened in that 10-year period. In 2009, the mayor's office, in partnership with CJA, opened the first supervised release programs for non-violent felony offenders in Queens. The second supervised release program for non-violent felony offenders was opened in 2013 in Manhattan, and then by 2016, I believe March 2016, supervised release went citywide for non-violent felonies and for misdemeanors. There was an earlier Brooklyn misdemeanor supervised release program opened by the court system, I think around 2012, might have been 2013. So you can see that in some of the trends as influencing the ROR rate, because defendants who were offered supervised release without money bail were coded as ROR. There's a new code introduced in 2016, release under supervision, so we'll be able to track that going forward more rigorously.
And can I just add one little factoid to that? So we think that actually when we look at the big drop in the jail population, it's been over 20% in the last 4 years. That one of the major drivers has been exactly what Michelle is talking about, which is supervised release, that is stopping people from even entering jail. And so it's been a very, very significant driver. And to Jim's point earlier, I think one of the things that made it successful was that it was crafted with judges, NDAs, and defenders, and so there was very, very enthusiastic uptake of it.
And so I think one of the things that I want to point out is the importance of time frames. We're presenting data in a couple of different ways in terms of time. We have 30-year trends that we're reporting. We're taking a little deeper dive in the last 10 years, and then some of the data Frida is going to report in a moment looks at the period, the 14-year period after we last changed our pretrial release recommendation system. And so important for us to be able to swivel around in different time frames. Interesting, as we've been talking about supervised release, if you look at the 30-year trend, it doesn't appear at first glance that the ROR rate for felony defendants has changed that much, but in the last 10 years, it has actually changed considerably. So, Frida, do you want to talk about the impact of the CJA recommendation? Because I think in some ways that's kind of a part 2 to the ROR story.
And I think it also really captures the past, the present, and the future. CJA's original recommendation basis was relying on what had been found by the Manhattan Bail Project, and that is that defendants with strongest community ties were the most likely to appear, and relative to that standard, people with somewhat weaker ties would be somewhat less likely to appear if released on recognizance, and then one can, as an actuarial model, go downwards. In the late 1990s, CJA embarked on a major research project that had several goals. One was to see if statistical models could be developed that could better predict the factors most closely associated with court appearance, to increase the proportion of cases in which defendants would be recommended for release on recognizance, and spoiler alert, also ensure that the appearance rates were not affected by this new recommendation classification system. And so CJA so that's really the future. And I want to say, for those of you who were not here at our first event, Elizabeth Glazer deserves an enormous credit for taking the Mayor's Office of Criminal Justice funding to really support a new massive research project using preeminent researchers in the pretrial field to help New York City create a new and better recommendation system. So stay tuned, forthcoming. And that certainly is the future direction of risk assessment for pretrial release in New York City. So what happened after CJA created this new recommendation system in comparison to what happened before? And I think on highlight 5, you can see that CJA did indeed achieve its goal of increasing the proportion of cases in which defendants would be recommended for release, and let me add, barring exclusionary factors. There are circumstances in which CJA will interview the defendant, provide that information to everyone at the criminal court arraignment, but will not make a prescriptive recommendation. And one of the things you can see here is that one of those categories is that CJA does not make a prescriptive recommendation if the defendant has an active criminal court bench warrant attached to their criminal history report, and leaves to the court system and the stakeholders to determine the relative weight to give to that bench warrant in light of the other factors about the defendant and the particular case that's being arraigned. One of the things, though, that I think becomes quite clear is that CJA did indeed achieve its goal of increasing the proportion of cases in which we could prescribe a release on recognizance. Well, that's all very well and good, but what happens when it comes into the courthouse? And I think the most important thing that could be a takeaway from slides 5, 6, and 7 is really found in bold toward the bottom of highlight number 7. And that is that we found greater agreement between the release decisions and CJA's recommendation, so that when CJA did recommend for recognizance release, we saw a marked increase in the proportions of cases in which judges, in fact, were releasing on recognizance. And that occurred for both felony and non-felony prosecutions. Although you can see by looking at these slides that judges are less likely to release when there is a felony prosecution. So the rate of release for felony prosecutions will be lower than non-felony prosecutions. And for researchers in the pretrial justice field, one of the most fascinating elements of empirical research meets reality is that there is a common perception that defendants facing felony prosecution, if released, are less likely to appear than defendants in non-felony prosecutions with the same characteristics. And in fact, the empirical research is just the reverse. And so this is, I think, one of those times where, for those of us who are trained academics, but we work in the policy world, where research and policy, you want to have a conflict, let's have a conflict over that one.
And so, Liz, you want to?
Yes, can I inject some conflict?
Yeah,
Okay.
good. I felt the tapping on my shoulder. It was the signal, yes, yeah.
So One thing that has struck me about our justice system, particularly when it comes to bail, ROR, and how judges actually take these recommendations or what they actually do in the courtroom, is that there is a high degree of pretextualness going on, meaning that we have a system, we're one of only a handful of states that do not permit a judge to consider danger when they decide to set bail on a defendant in front of them. And the reason why I say that, and I think that that has a kind of pernicious effect on how decisions are made, because when a judge, whether this is grounded in the research or not, sees a violent felon in front of him or her, or a felony, they will have a different response that's based really not so much on what Frida was rightfully talking about, which is whether they will appear in court or not, but whether or not that defendant will reoffend. And so one of the things that I was sort of struck by, and I may be reading this wrong because I'm not a researcher, is that was the high degree of disagreement with the not recommended for release or the high risk. And note that that's high risk of failure to appear when all the flashing lights and colors in a decision maker's mind may be thinking about danger.
Yeah, and do you want to follow up on that point?
Yeah, because I think it's important to note, look at the orange and red bars. What happened between 2004 and 2016 is ROR rates went up in every category. So the orange, I want to be precise for a reason. When we say not recommended, we're talking about not recommended for release on recognizance. That doesn't mean recommended for detention necessarily. And when we developed supervised release, one of the things we realized was that people who might have a high risk of failure to appear might mitigate that risk if they were in supervised release. Right. So one of the things that may have happened in the lighter orange bars is that even though they weren't recommended for ROR, they might be eligible and for supervised release. And so the growth in release for that population may be driven by the availability of expanded programs. Mm-hmm. And so judges are taking more risks with a risky population than they had taken in the past.
And with more comfort, meaning because they have supervised release.
And that was true both for the non-felonies and for the felonies. But remember that supervised release for felonies is only available for the non-violent felonies, so the growth in the light orange bars isn't as great as it was for the non-felonies overall.
And I think that obviously this story of how a greater proportion of defendants are being released on recognizance in New York City, there are a number of factors to account for it. But I want to take a step back and just say, for me, the idea that ROR, which was, again, this institution and even sentence that was created through the Manhattan Bail Project, has over the years become even more integral to the system, I think is a fascinating story of the diffusion of an idea. So you look at an idea that's proposed that has, that is almost described as a pilot in its early stages. I mean, the idea of an ROR was new, it was exciting, and it had a lot of advocacy behind it. But now that we are decades later, the energy and the enthusiasm tends to be for things like supervised release, for the bail funds, et cetera. Now, supervised release certainly contributes to this increase in the ROR rate in this period when we weren't unpacking it from ROR. But I guess I just wonder, what does it say about the ability of certain ideas to not just survive the pilot excitement phase, but to continue to thrive and evolve over decades in unexpected ways? And I don't know if anyone wants to speak to that. Yeah, go for it.
So I'll leap in. So I think that's actually an incredibly interesting way to think about kind of culture change, which is really what changes in decision making and releasing folks is about. in which you have, as sort of Aubrey says, this kind of stepped approach where first there's an agreement like, yeah, ROR, good idea. You know, we ROR more than twice the number of folks from, you know, that beacon of a no cash bail system, Washington, D.C. So it's a huge piece of kind of this culture of release that we have. But then the diffusion and the huge take-up of kind of the next step up, which is, well, they're not really ROR folks, but with a little something more, this person doesn't have to be in jail. They can be waiting for their case to resolve at home. And that's sort of the supervised release story. So what is the next story that we want to tell? And I think it really comes down to two things. One is, how do we think about people who are charged with violent offenses, which, as we know from research, these are not folks who necessarily have higher failure to appear rates or, frankly, even higher recidivism rates, reoffending rates. So is there an option with respect to how to change culture there? And sort of the second piece is, you know, something that I touched on before, which is, and what are the options for release for people who may score very, very high on failure to appear because they are homeless or they have behavioral health issues? And are there things that or they have warrants, right? You score very high with a warrant, even if that warrant is drinking alcohol in public, right? So what is it that we can give comfort to judges on the way we've done in ROR and in supervised release with these two groups, which, you know, I think are the next frontier?
Yeah. And Jim or Frida, do you want to add before we move on, Jim?
Just one small point that I have is, I mean, I think we have had and we need to continue to have a discussion in New York about how the safety of the community should feed into pretrial release and pretrial detention, and the whole rest of the country considers it relevant, and here we're a holdout on that. I think that needs a good look, a continuing look. But the other thing is witness intimidation and witness tampering, and that all just seems to always drop out of the picture altogether, and yet it is a factor. We don't know how many cases, how many times a person is released and then threatens witnesses or offers inducements to witnesses to get lost and so forth. But that obviously undermines the integrity of the criminal justice system, and also could quickly lead to lack of cooperation from witnesses who felt that they were being threatened. So I mean, I think that has to be promoted along with safety of the community and likelihood of making court dates.
Yeah, just maybe to make a quick intervention here, I'm going to read a comment and then a question for Michelle as we transition to our next headline story. So an audience member has pointed out, looking at highlight 7, that it's important to note that over the period 2004 to 2016, that all ROR rates increased in all of the recommendation categories, and that the percentage increase is higher in those not recommended by CJA than those who have been recommended, which I think is an issue that we touched on in terms of the new options that were available for some of those defendants who might have been in the orange bars. But it is also worth noting that even in the red bar, which is not recommended because of an active warrant, right? That would be considered more of a red light for a judge. Judges are more likely to ROR those defendants, which I think is an interesting case of another factor that may be going on, which is the kind of increasing risk, the aptitude that judges have for releasing defendants even in risky circumstances. All right, so we're going to move on to a next headline story for us around bail and bail making.
Did you want to ask me to?
And I have a question we're going to ask Michelle to start with from the audience. And also, before I ask this question, I want to encourage people. We passed out these note cards that say, stay connected. If you fill it out, put your name and your email, and check boxes of what kinds of topics you're interested in. We'll be sure to email you new report releases when they come out. Okay, so on to the question of bail and bail making, which is a hot topic and deservedly so in the city. Question for Michelle. Please describe the first 3 days of incarceration and why they are so expensive.
So I may turn to Mike Jacobson, former commissioner, if I get this wrong, former commissioner, but I think it has to do with assessment and classification. And there's a lot of physical health and mental health assessment that happens in those first 3 days, and then risk assessment, a lot of interviewing. So there's a whole bunch of staff that are stationed at the jail, some of whom are health employees as well as correctional employees. Is that pretty much it, Mike? Yeah.
And congratulations to the city for releasing its new online bail payment system last Friday, which is designed expressly to avoid this problem of defendants who go into the system but are only there for a few days.
And Liz reports we had our first online bail payment over the weekend.
Yep.
Wow, that's incredible. All right, Michelle, let's take us through bail and bail making.
Okay.
Tell us some of the highlights that we found in our report.
So these are highlight 8.
8 and 9.
Wait. Okay, my page didn't turn to the right place. Okay, so one of the things we looked at was also the likelihood of having bail set at arraignment over time, and this is in the 10-year period. And you can see that partly because of the increase in ROR over time, the likelihood that bail would be set dropped for felonies from 58% down to 53%, and for misdemeanors, and these are for cases continued at arraignment only, from 28% down to 21%. This led to a substantial reduction in the number of bailed cases. These are cases, not people entering the jail because of bail making and because some people have multiple cases, but the number of bailed cases overall dropped from almost 66,000 to a little over 43,000 from 87 to 2016. So this is the longer term. This is the 30-year look. Felony bails dropped from about 35,000 down to about 24,000. Non-felony bails dropped from almost 31,000 down to almost 19,000. So a big reduction over the 30-year period in the number of cases with bail set. And then highlight 9 looks at bail making over time. And on the bottom of the page, you can see that bail making, which at arraignment is relatively rare, didn't change much for felonies. Actually went down a little from 9.1% to 8.8%, but basically the same. But what we did see was a substantial increase in bail making for non-felony cases, up from 11.5% to 15%. And I think if we look towards the future, this is a trend that we'll see expanding. One of the new features over that decade in New York City was the introduction of the city's first bail fund by Bronx defenders, and I forget the year in which that actually happened. There was some litigation and then it went into effect, but after, within 2 years of that happening, I asked a research associate at the mayor's office to take a deeper dive using CJA data to look at the 5 boroughs of New York City and to look at bail making for misdemeanors in the year before the bail fund went into effect and in the year after it went into effect. And at the time, it was only active in the Bronx. And what we saw was a very substantial increase in non-felony bail making in the Bronx, but not in any of the other boroughs. Since then, the Brooklyn Bail Fund has been established, and the citywide bail fund went into effect over the past year. And we asked Frida to take, so bail funds by law are permitted to post bail for non-felony defendants with bails of $2,000 or below. We asked Frida to take a look to see if this increase was concentrated in that range of non-felonies, and the answer was, yes, it was. And I was sworn to secrecy, but we asked her to take a look ahead at 2017, in which we had even more bail fund activity. And I'd say in the next annual report, we're going to see a very substantial increase in bail making for the non-felony population throughout the city.
And just one addition. So we very much have our eyes on the prize of reducing the jail population, so we follow very carefully sort of how all kinds of things affect the bail population, the jail population, and this is all public information, it's up on our website, but we found that in the last 4 years, the number of folks who are in on 2,000 and under bail has dropped by 60%. So this is not all bail funds. There are a whole bunch of different things happening, I think, to accomplish it, but it's a very, very significant trend.
And
Can I just jump
Go ahead,
in
sure.
quickly there? And it's, whenever we talk about bail, it's important to say that bail, in theory, should be a way of releasing people.
Right.
I mean, this is a technique of releasing people. How can we feel confident that this person will appear and so forth by paying bail? If they can't pay the bail, then maybe there's some other way that we could feel assured. In practice, it often is thought of and indeed operates as a way of keeping people in jail. How much bail can we impose so that the person is unlikely to make it and then will be kept in jail? I mean, it just turns it on its head, and it shouldn't function that way, and it's irrational to function that way. So I think from an academic standpoint, we tend, and as someone who teaches this stuff, we tend to think of bail as essentially irrational. The idea that by putting up money, you'll be more likely to return to court. And it's even more irrational if someone else is paying the money, whether it's a bail bondsman or a bail fund. So, I mean, put that in your pipe and smoke it. Somebody is putting up the bail for you with the idea that this makes it more likely that you will appear at your court dates. It just doesn't make any sense, and the more that we can move away from that, and the faster we can, the better.
This seems like a good time to ask Liz a question that was suggested by an audience member. Could you please discuss the state of ending cash bail policies?
Sure, so that'll be a short answer. So to end cash bail, we have to change the statute. We operate within the structure of a state statute, and the state statute is essentially what establishes the cash bail system. So that's kind of the short answer. Until we have legislation, that won't change, and getting that legislation is very complicated, a lot of different interests, a lot of different issues. While we still operate within the confines of cash bail, I think we are, our focus is to work every single day, and this has to be all the partners in the system, because it's hydraulic, to mitigate the effects of cash bail. I think Jim's point is so right. Bail was considered a great reform, a reform to ensure release, and we've seen other things happening because of something I hope we'll talk about, which is sort of really kind of this vein of inequality that runs throughout our system. So what can we do in the interim? We can ensure that we have as many ways to divert people from going in as possible. Supervised release is important. That we have as many ways of easing the way to pay it, so that so that people don't go in and cash and bail funds are those things. But the last thing I will just say, and as a result of all these things, I think we've seen these big kind of drops in the population in jail. But the last thing that I would say is that as long as we have a system in which judges are not permitted, except in very rare instances, to hold on danger, we see cash being used as a proxy for danger. So the more risky as far as reoffending, the judge may see the person, whether the judge is right or wrong, the more serious the offense, the higher the amount of money.
Yep. But I think it is worth noting.
Can I just add one other factoid that is actually quite important in this? Even if every person who was in Rikers today had their bail paid instantly, half of them would still be in. And the reason for that is that there are other holds on folks. There are warrants, probation, parole, and an array of other things that keep people in jail. So ending cash bail is absolutely a form of the good. It doesn't end jail.
And just to add another point, the mayor's office has been terrific at looking at this problem of short stayers, people who have bail set in the case, but pay within a few days of entering incarceration. So we know, for example, that something like 75% of those defendants who did not pay bail but will pay bail at some point in the pendency of their case, pay it within a week. But if you were to fix that problem, that is to move all of those people who paid on day 2 or day 3 or day 5 and have them pay bail at arraignment, the actual impact on jail beds at Rikers would be fairly minimal because you're adding up a lot of people who are there only for a few days. And so I think that's, just as Liz just pointed out, that, you know, there are complexities and subtleties within this debate around how you reduce the city's jail population. There's also trade-offs. There are things that are important to do even if they don't have an overwhelming immediate impact on the city's jail population, because we know that being incarcerated even for a couple of days has tremendous negative impacts on the person and financially on the system. So anyway, I think important for us to take a deeper look at some of these issues. All right, so we're going to move to our fourth highlight in a moment, but I do want to make sure that this format is lively, and we're getting a lot of great questions. So I want to break in with one question that was submitted, and I think Liz may actually take the first shot at this one. So the question is, the data in these reports is largely snapshot data, highlighting specific data points and identifying a point-to-point trend. But none of these data captures the lingering social or economic costs to the individual people who make up each of those data points. Does that data exist, and where can the public access it? Or why does that data not exist? That's a great question. We're looking at administrative data for the most part, system data. But how do we look at this sort of more complex set of questions?
Well, this is a little bit of what I was getting at the very beginning. So we have seen this remarkable set of trends in New York. It's true of the entire country that there's been big reductions in crime and even in incarceration. It's just been much steeper and much more durable. And both trends, both crime and incarceration, has come down at the same time. But what has not moved is where people who are arrested and who fill our jails come from. So when you look at sort of the intertwining of violence and inequality, you look at sort of what are the top 10 precincts that in the early 90s led the city in shootings. So in the early 90s, we had in one precinct as many shootings as we had last year in the whole city of New York. And those top 10 neighborhoods in the early 90s, when the city was a much more violent place, 7 of them are identical today. And then you look at what else is happening in the neighborhoods that are leading the city in violence, and they're largely poor, suffer from a lot of other indicia of distress, high asthma rates and low birth rates and high unemployment and low educational achievement. They're largely African American and Latino neighborhoods. And so that's what I mean by saying there's this enormous kind of vein of inequality that runs through everything. And then when we come to sort of the world of small crimes, right, sure, we have seen a huge reduction in things like stop and frisk, right? We were at almost 800,000 at its peak, again, focused in these very same neighborhoods. You know, last year we were down to about 11,000. Everything's down, 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 summonses, et cetera, but always still in these neighborhoods. And so it comes back to this issue of, is it like marijuana, in which the use among, whites and African Americans is the same? It's just that where the policing is happening, or what the openness of the behavior is more concentrated in African American neighborhoods, and so there are more arrests. Well, that's pretty terrible. And the same thing with other kinds of quality of life offenses. So that requires, as I said at the beginning, really kind of blowing out the doors in what we're looking at, and really sort of thinking and looking very carefully at neighborhoods, at all this data by neighborhood, and by trying to sort of get underneath just the data to understand what's driving this.
And one thing that I'd like to add from CJ's perspective is, as we've mentioned, we interview nearly every arrestee before they see a judge for the purposes of producing a pretrial release recommendation. And we gather a lot of data about community ties and about the defendant's criminal history, and that includes where they live, certain demographic information. And one of the things that we've been thinking about as an institution is how to kind of safely and responsibly, when you think about issues like privacy and confidentiality, use that pretrial interview as an opportunity to kind of determine information that is more broadly relevant about these types of issues. I mean, we know a lot already that just by nature of the questions we ask about things like how many defendants enter the system every year and report that they're street homeless. We have a lot of interesting information that we're able to extract even from our existing interviews. And that type of information cuts across these issues. It's not just an exclusively criminal justice administrative issue. It speaks to some of these issues around inequality and race even. Okay, so
And,
Michelle, yeah.
Just to remind people, on the CJA website, Rick Peterson did a study of the populations who identified as being homeless. Came out a couple of years ago, right? And differences in outcomes for homeless defendants compared to other similarly situated defendants. So it's worth looking at, but part of having the data permitted that kind of analysis, to look at special populations within the system and to see if they were treated the same or not.
Right. Okay, so we're going to move to our last big highlight section. And actually, I have a question that Frida doesn't have to answer right away, but I want to just note it because it will be answered in the course of her highlight presentation, which is a missing piece of data in this pamphlet is the court appearance rates by each category of CJA. So for example, the rate of appearance when CJA rates someone as high risk versus low risk. So in other words, how predictive is the CJA pretrial interview? And we will talk about DATs, but we'll get into appearance rates of non-DAT cases. So I want to make sure Frida answers that question.
Is it a spoiler alert, so I shouldn't answer it now?
No, go for it. Yeah.
The answer is we do very well. That, in fact, if CJA has recommended someone for recognizance release, they are released. The likelihood that they will show up is highest, and relatively lower appearance rates. But here's the real spoiler alert. New York City is astonishing in the rate at which people show up if released on recognizance. And that was the spoiler, because that's really the last slide. But I do want to talk a little bit about desk appearance tickets. They are an absolutely fascinating subject for people who watch what criminal justice policy gets made and as it changes from one administration to another. And what we have here are data that cross 5 city mayoral administrations and 10 different periods of police commissioners. 2 of them repeats, so there really were 8 people spread across 10 different periods of time. A desk appearance ticket can serve a variety of purposes. When a person is arrested, if they're brought to a precinct house and the charge is a non-felony, there are only a handful of e-felonies that are ever eligible for a desk appearance ticket, there can be a decision about whether to hold the person in custody for the criminal court arraignment or to release the person with a summons telling them when to return to court for their arraignment and any subsequent appearance. And desk appearance tickets can serve a variety of purposes. They can serve as a means of releasing pressure on custodial arrests, which have to be arraigned within a 24-hour window. They also can be a way of diverting from the kinds of consequences people face from custodial arrest, people who should just simply be released and told to come back. And how the policies toward desk appearance tickets over administrations change, I think is very well highlighted when one looks at the highlight number 10. And one can see the kind of roller coaster that has gone on with respect to the issuance of desk appearance tickets. So such that in 1999, there were only 15,290 desk appearance tickets issued for the entire year in New York City. By contrast, in 1997, there were 78,595 desk appearance tickets issued. In this same period of time, we were seeing the full effects of order maintenance policing. So that this is not a function of, well, we just had fewer non-felonies coming into the system. This was a very conscious decision that was driven by, I think, 2 very important things. One is looking ahead to highlight 11, that the failure to appear rate for disappearing tickets was particularly high at various times. Over 40% of defendants issued desk appearance tickets for a very long period of time did not show up for their arraignment, which led to real concerns about the use of desk appearance tickets. But the other thing that happened during the height of order maintenance policing was that inadvertently a violent felon was issued a desk appearance ticket because the criminal history had not been returned at the time the desk appearance ticket was issued. The defendant failed to appear for arraignment, and when the warrant squad went to serve the warrant, the result was a rather violent confrontation in which both a police officer and the defendant died. And there was an immediate revision by the Giuliani administration over the policies regarding the issuance of desk appearance tickets. And so for most of the remainder of the Giuliani administration, desk appearance tickets were highly restrictive with respect to their issuance. And one sees that as administrations change, there has been an increase in the use of desk appearance tickets, even as the overall volume of misdemeanor arrests and non-felony arrests have been going down. And I do want to call attention to something that the current administration did beginning in April of 2013. Policy toward the issuance of desk appearance, let me restate that. This administration changed the policy with respect to arrests for low-level marijuana. And the decision was made that in most circumstances, defendants who were arrested for low-level marijuana possession were not to be held for criminal court arraignment, but instead were to be issued desk appearance tickets. And so one can see a surge in desk appearance tickets in 2014. And then this administration has gone further in urging that instead of even desk appearance tickets, that low-level possession should be treated as simply a street-level summonsable offense, if at all, and we know that the result is that we are seeing far fewer arrests for low-level marijuana possession. So that programs and policies from one administration to another become, I think, a very critical driver of the use of desk appearance tickets. When we saw, if you go to highlight 11, as desk appearance tickets became far less frequent, one also finds that they were being issued very selectively, and return rates were very high, but off of a very small number of desk appearance tickets issued. And one of the concerns, I think, today is that we are beginning to see an increase in failure to appear rates with respect to desk appearance tickets. And I would call your attention at the very back of this publication. There is a presentation about a kind of primer, a sampler of our research briefs, and I would urge everyone who is interested in the issue of desk appearance tickets to go to the CJA website and look at a report done by our former colleague, Dr. Mary Phillips, which actually looked at the changes and the uses of desk appearance tickets. And I don't want to repeat the wonderful work that she did, so I urge you to take a look at that particular report. But there are collateral consequences when desk appearance tickets are issued and defendants don't show up and a warrant is issued. And I want to bring that back to why have we seen, and the question that was asked, why have we seen an increase in the ROR rates in cases in which defendants were held and CJA said, we are not making a recommendation because there is an active bench warrant, and leaving it up to the courtroom stakeholders to make a qualitative assessment about what that bench warrant was for. Why did it occur? How long ago did it occur? Was it for a desk appearance ticket? Was it for a failure to pay a fine? And I think that one of the reasons that we have begun to see an increase in releases among those for which CJA says, we cannot recommend because you need to determine the importance of the the warrant, is because of this increase in the failure to appear rates among defendants issued desk appearance tickets. And one of the collateral consequences to not showing up is that when that warrant is issued, if you are arrested for, again, for any reason, and that warrant is found, it requires a custodial arrest. So I think one of the new elements in pretrial justice are programmatic initiatives that can increase the return rate for desk appearance tickets so that we are not, in fact, doing a disservice to those individuals that we are trying to prevent from a custodial arrest, but having more serious consequences potentially for them down the road. So I think desk appearance tickets and finding ways to create programmatic initiatives is a very important piece of where we need to be looking in terms of our future research. And I think that there is another aspect to the issuance of desk appearance tickets, and that is, although you can see this in our annual and semi-annual reports, but it is not reflected in these highlights, is that appearance rates on desk appearance tickets differ by the nature of the offense. And we need to do a better job, I think, of understanding why for certain types of offenses do defendants not appear with the same frequency as other types of offenses? And I am not suggesting here that we don't issue desk appearance tickets in those cases, but I think we have to figure out how we can target our programmatic initiatives to maximize the return rates in those kinds of charges in which we know that defendants are relatively more likely to fail to appear. And one of those crime categories happens to be when desk appearance tickets are issued for turnstile jumping, has one of the highest rates of failure to appear.
Yeah, and I think one thing I want to point out about how we presented the data itself is historically we've always reported the failure to appear rate. So we've always focused on the percentage of defendants who do not show up for their court obligation. In response to a lot of feedback we've gotten from the stakeholder community, we've decided that that's kind of a negative way to frame the issue. And so now we're talking about court appearance rates. And in part because, as we've discussed, the court appearance rate of defendants in New York City is so very high. So as Highlight 13 shows, in 2016, 86% of defendants released to the community pretrial made all their court dates, which to me is really a remarkable finding. And if you adjust that to include those who return within 30 days, if they did not make a court date, that percentage goes up to 93%. And it's of interest to me that I don't think that's a statistic that is known by all the players in the system, but it feels to me like the kind of statistics that would bolster one's confidence in this idea of releasing someone to the community, even if there are other obvious issues that judges and others are concerned about, such as reoffending. So Frida did a great job of presenting a lot of information about desk appearance tickets. And what I think is really interesting about this is that the fact that we are returning to a place where DATs are being issued more often, and where even cases that used to get DATs are being brought down to even a lower level in terms of legal consequence, in terms of summonses, I think that's a sign of a system that's trying to develop a more humane approach. But even here, there are trade-offs. If you give more defendants desk appearance tickets, that will increase the failure to appear rate, that will result in more warrants, and so the system has to make adjustments even when it's trying to be more humane, because the defendant who warrants on a desk appearance ticket may be worse off than if they had been arrested and brought into the system in the first place. Liz, do you want to say anything about this kind of strategy of de-escalation in general, or about the DAT story?
So I guess one of the things I'd be interested in just seeing what the rate is, because we see the absolute number, but I think as Frida pointed out, it's over a smaller denominator.
No.
I get the math right? Yeah. Okay. I think there's been quite an intentional effort by the city to lighten the touch. We see it in the remarkable drop in numbers of summonses, in numbers of arrests, both misdemeanor and felony, and in the general shrinking of the system. And so I think that when you look, there are kind of two issues, I think, that policymakers, politicians, and New Yorkers think about. One is the issue that we saw when stop and frisk was something that people were urging needed to be pulled back, and that was, the streets will run with blood. That was clearly not the case, and that's been sort of demonstrated. Now we sort of move to the world of small offenses, ticketable offenses, summonsable offenses, riding your bike in the park after dark, sitting with, it always sounds like a Dr. Seuss book, feet on the seat, park after dark, drinking alcohol in public. But these are very significant and important issues, and they have an impact well beyond just the inconvenience of a ticket. It feels sort of like the hand of the state on controlling behavior in a way that doesn't necessarily have to be. But there, as the issue is, sort of as that has been pulled back, it's not so much will the streets run with blood, but will the streets run with urine? That's what people care about, are these things where, you're peeing in my front yard, your true concerns from neighborhoods about quality of life. And that we don't have that great a way to measure. And so I think, when I think about it, I think we think about, and I'm going to do something very scientific right now, we think about the reducing crime rate, which is going down like this, and we think about the reducing enforcement rate, which is going down even further, and the space between my two arms is the space that we have to move, to de-escalate. And that's the thing that we have to focus on with great precision and care.
So we have about 5 or 6 minutes left, but I wanted to go through some questions very quickly. But one thing I wanted to ask is, this trends analysis is the first time we've tried to do this exercise of looking at years of data reported in our annual and semi-annual reports. And I'm sort of curious if there are open questions on the part of the panel, things that people would like us to dive even deeper into.
So I've been curious about the last 10 years where the CJA data is richer than the 30-year span, because more was being collected, more was being automated. And some of these trends, for example, increasing ROR rates, you'd want to know, well, what's happened borough by borough? Are some boroughs have the changes been more pronounced in one borough than in another, or more pronounced for particular types of offenses? So I think there's a few key variables you might want to control for, particularly breaking down violent felonies and nonviolent felonies, things like that.
I agree. I think the borough by borough piece is an incredibly important story, and I would actually say neighborhood by neighborhood.
And I'm sure it'd be interesting to see it broken down by type of arrest. The crime for which you arrest is a person who's been focused on gun crime for the last couple of years. It'd be very helpful to know what happens with arrests for guns as well as for other weapons.
And just let's talk about neighborhood by neighborhood for a moment, because that's a really interesting kind of new twist on what we might be able to do. So is the issue, I understand looking at how boroughs put into motion greater or lesser propensity to ROR defendants. But for neighborhoods, are you saying, are there particular neighborhoods that arrestees are returning to, who are more or less likely to be released to the community?
I think that we see this sort of $1 million block issue.
Yeah.
And we should be very clear-eyed about it, and we should understand it, and we should address it.
Yeah.
And I think it runs against a background of, there have been real disparities, certainly when it comes to violence, between the different boroughs. And why is that? And to what degree is there an intersection between what the justice system is doing and the violence issues?
So we don't have a lot of time, so I'm just going to read a couple of questions and some statements that this audience has submitted, and I'll leave it open to the panel to decide whether or not they want to respond. Okay, so we've talked a little bit about the issue of how to promote alternatives for felony defendants, and supervised release being one option, but it does seem clear that that's an area, if you were looking to grow the ROR rate and reduce the jail population, that you really have to fix. So one question is, has MOCJ identified approaches for increasing releases of those with mental and substance abuse disorders and those charged with violent felonies? So I'll leave that for a moment and read a couple of other ones. Are there surveys of judges, presumably anonymous, as to the weaknesses and strengths of CJA, the release recommendation, from their point of view? And then I can't help but read this one, and wondering if the Arnold Foundation is still in the room. CJA is a national leader in criminal justice data and analysis. Do you try to promulgate, share, and teach CJA's methods and approaches with other jurisdictions? And are there other governmental criminal justice data organizations whose work you admire and seek to include in CJA's work? So, Liz, do you want to take the violent felony question or any of the other
Remind
ones?
me, just because I have a
Has
brain
MOCJ
extra phone.
identified approaches for increasing releases of those with mental and substance abuse disorders and those charged with violent felonies?
Yeah, so I think both of those are crucial. We do have one of the world's greatest experts on at least the behavioral health issue, which Joel Copperman is here, and he and cases do some amazing work on folks who suffer from behavioral health issues. So yeah, there are a bunch of things that we're working on, not just ourselves, but every single thing that we do must be done with defenders, prosecutors, and courts, and in some instances with the police department and the corrections department as well, in order for them to be accepted and actually used. But it is a very, very big issue when you have a system that's structured in such a way that people who suffer from this sort of from this combination of homelessness, health issues, and repeated contact with the justice system, structurally, they will look to a CJA risk assessment instrument like a very risky population. They won't return to court. And we see this even with our bail funds. We look every single day and work with the defenders and with the bail funds to see if there's anybody in jail under $2,000. And why is it that they're not being picked up by bail funds? So sometimes they're not being picked up by a bail fund because a bail fund may not want to take the risk because the person may suffer from other issues like behavioral health issues. And so how can we, again, give confidence and comfort to judges who release or other parts of the system that are there in order to ensure that people are out of jail when they suffer from an array of issues that the release recommendation and other things weight heavily against release.
I would just add that it's not just the release of people who are already in Rikers, but as we sit here today with the support of the Mayor's Office of Criminal Justice, the early pre-arraignment screening unit in Manhattan has now expanded its capacity by having the Criminal Justice Agency have a court staff person who will work as a liaison between the health screeners that are being done, the health screening, and the defense bar, to try to ensure that if one can do early identification of someone with behavioral health issues, is it possible to begin to plan to divert that person before they even come before a judge at arraignment? So I think that it's not just, okay, what happens when our jails become alternatives for the housing of the mentally ill, but how can we intercept those individuals and try to divert them so that they get the help they need without having to be diagnosed at Rikers Island. And we thank the Mayor's Office of Criminal Justice for allowing us to attempt this experiment, to expand this program in Manhattan, and to try to see if diversion can work to begin to identify early on and remove from the full impact of the criminal justice system those with behavioral health issues.
So I think unfortunately we've run out of time, and I'm sorry to anyone who submitted some of these great questions and comments that I didn't get to. But why don't we conclude with a round of applause for the panel.